I want to comment in relation to what happened in court yesterday, where the charges against one Rose Njeri were rejected by the court as not disclosing any cause of action. And pursuant to that, media houses have carried a story condemning the Director of Public Prosecution to that effect. I want to put this very, very clearly as one of the practitioners in the criminal justice system. I practice 90% in the criminal courts, and I'm well conversant with the law of the crime. The blogger, Rose Njeri, was charged. The court rejected that application to charge that Rose Njeri, and out of it, there has been a lot of criticism leveled against the office of the Director of Public Prosecution, or in person, the DPP himself. I'm commenting as an advocate of the High Court of Kenya, a specialist in criminal law, a practitioner in the criminal courts, and this is the true facts as it is. One, the office of the Director of Public Prosecution is created under Article 1. In Article 157(5), A, the Director of Public Prosecution can institute any matter before a criminal court in the Republic of Kenya. That mandate is exclusive to the Director of Public Prosecution. Therefore, after the police investigated, the file went to the Director of Public Prosecution. He approved the charges. Then, in Article 157(10), the Director has been given the constitutional mandate to institute those proceedings or charges without anybody giving him directions. Article 157 puts it very clearly. Article 157, Director of Public Prosecution shall not require the consent of any person or authority for the commencement of the criminal proceedings, and in the exercise of his or her powers or functions shall not be under the direction or control of any person or authority. That provision gives the Director exclusive jurisdiction to charge or not to charge. Therefore, the Director of Public Prosecution, one Renson Ngonga, did not require the authority, the consent, or direction of anybody to charge one Rose Njeri. Pursuant to those provisions, social media has put it that that is gross incompetence. I want to put it very straight. There has been no challenge in any court of law of the Cybercrime Act. What has been challenged, and the courts have declared sections of those laws unconstitutional, is one, if you look, the charges against him was that he had allegedly reprogrammed a mobile phone, which was against Section 84G of the Kenya Information and Communication Act. Section 84G, and let it be clear, is for the Kenya Information and Communication Act, which Justice Weldon Korir declared unconstitutional. There's a very clear distinction. Rose Njeri was not charged under the Kenya Information Communication Act. Equally, another judge, Justice Wilfrida Okwanyi, in her verdict, declared Section 66 and Constitution of the Kenya Information Communication Act. The two judges have only declared sections under the Kenya Information Communication Act unconstitutional. This was put to the life and to the attention of the Director of Public Prosecution, and that is why the Director of Public Prosecution charged Rose Njeri under Section 16 of the Cybercrime Act.